Hi everyone. In the last class, sorry. Hi everyone. In the last class, we have discussed about the certain important provisions of the contract that we have discussed about the indemnity, okay, indemnity and the guarantee, and that was mentioned in the chapter 6 of the Indian Contract Act, okay. So we have under chapter 5 discussed about the relations resembling that is created by the contract, and that we have also discussed by the reimbursement of the contract, okay. And under chapter 6 we have discussed about the consequences of the breach of the contract, that when the contract is breached, then what is the consequences of the breach and how it can be repaid or how it can be consolidated, that we have already discussed. In the next part, we have also discussed under chapter 7 under chapter 7 about the compensation by the party who is rightfully doing the contract. That if a party is rightfully engaging into a contract, then he or she has the right to get the compensation of the contract. That is what we have already discussed there. Then comes your chapter 8, which speaks about the indemnity and guarantee, and that is discussed under chapter 8 of the Indian Contract Act. So, when we are talking about the indemnity, what do you understand by the indemnity? Indemnity means compensating something, that when there is a loss or damage by a certain person or by a certain property, then when the part comes to indemnify, that means to compensate the another party, that is called the indemnity, okay. So according to section 124, a contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of other person is called a contract of indemnity. That means when there is a when there is a presence of the one party and one party promises to save other party from the loss caused to him by the conduct of the promisor itself. That means the person who is the promisor in the contract. There are usually two persons in a contract. The first one is the promisor and the second one is the promisee. The promisor is the person who does the promise, who is the maker of the promise, and the promisee is the person to whom the promise is made. That is what we have already discussed under the contract, okay. So under this we have discussed that when there is a presence of the promise, there are usually two parties are present. One is the promisor and another is the promisee, okay. So in this kind of contract in which by which one party promises to save the other from loss caused to him by the conduct of the promisor himself, that when there is the loss is happening to the party by the conduct of the promisor itself and by the conduct of the other person, it is a called the contract of indemnity, okay. That means, okay, sorry, I got a call actually, I had to take a break, yeah. So what I was talking about, that when there is a presence of a promise, there are two parties. First is the promiser and second is the promisee. When there is the presence of the promiser at a contract and the promiser is giving a promise to the promisee, that yes, if there is any kind of the loss is occurring in this contract by my activity or by the activity of any other person, I am here to pay you the compensation. that is called the contract of indemnity. We have already discussed it before that when we are talking about that there are mere kind of the contracts which we have already talked about this, in which this happens that for example there is a dangerous goods, there is the transaction of the certain dangerous instruments through the ship, okay, and while transacting the ship from one country to another, there is the presence of the guarantee for the specific ship, that if the ship is facing any kind of the issue in it, that is called the insurance for the ship, then the party who is the owner of the ship, the party is going to be get the compensation of 3 lakh rupees or 4 lakh rupees, okay. So this is also a kind of the contract in which the promiser who is doing the promise or who is ensuring to pay the damages for the contract, for the contract of the losses occurred, okay, he is promising that if there is any kind of the loss or damage is occurring in this contract by me, by the promiser himself, or by any other person, I am here to pay for it, then this kind of the promise or this kind of the contract to pay the compensation is called the contract of indemnity. Got it? Then next point, section 125, it speaks about the rights of the indemnity holder when sued. Okay, what does it speak? The promisee in a contract of indemnity acting with the scope of his authority is entitled to recover from the promiser. So, under section 125, there are certain circumstances have been explained when there is the right of the indemnity holder to sue the promiser to pay the compensation or to pay the specific amount that has been prior decided. Okay, this is the major criteria of the contract of indemnity, that whatever amount of the compensation has been fixed, or for example, I have given a contract of indemnity that I am going to pay you the uh, compensation up to the amount of 10 lakh of the rupees if the ship is facing any kind of the issue, or if the ship is getting destroyed. So here, when we are talking about the contract of indemnity, I am the promisor over here and the another person is the promisee over here, okay. So, in this specific contract, okay, the promiser is liable to pay the compensation up to 10 lakh of the rupees if the losses or damages is being occurred to the party itself. Okay, so the party cannot get excuse from the contract of indemnity. The party cannot stop stop giving efforts or fulfilling his or her own promises to the another party for the contract of indemnity which he has already did. Okay, so when under section 125 we are talking about the rights of the indemnity holder, then who is the indemnity holder? The person to whom the promise of the indemnity has been done is called the indemnity holder. That means there is a person, one person is the promiser, and the second person is the promisee to whom the promise has been done. The person to whom the promise has been done is called the indemnity holder of the party. Got it? So when one party is the indemnity holder over here, then in that circumstances, the promisee or the indemnity holder has the right to recover from the promisor. What the indemnity holder can do? The indemnity holder has the right or has the responsibility, has the duty to recover from the promisor. What he can recover? Point number one, all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnity applied. Okay. The first point, all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnity applies. There is a specific jurisdiction of the application of the indemnity contract. As I have mentioned in the contract that I am going to pay up to the losses of the 10 lakh in your business. अगर तुम बिजनेस करते हो और तुम्हारा बिजनेस पे कितना भी अमाउंट का नुकसान होता है 10 लाख तक जितना होगा आई विल बी कंपेंसेटिंग यू. दिस इज माई कॉन्ट्रैक्ट ऑफ इंडेमनिटी फ्रॉम माई बिहाफ. हियर I have the extension limit. I have the boundary to help you out up to the amount of 10 lakh only, not exceeding than 10 lakh. Got it? So when I am having a specific limit or specific boundary to perform my part of the contract or to perform my part of the promise, and I am bound to perform that much portion, then I cannot excuse from that, and I am here may be compelled or forced to pay in that suit in respect of any matter which I have promised and to where the indemnity each applies. Got it? That means if I have given a promise that I am going to give you or I am going to pay you up to the amount of 10 lakh of the rupees in for your losses in the 2 months, then here only I am bound or I am compelled, I am a mandatorily I have to pay the amount up to 10 lakh of the rupees to the business holder or to the indemnity holder for the contract of indemnity. ये हो गया आपका subsection 1. Next point, all cost which he may be compelled to pay in any such suit if in bringing or defending it he did not contravene the orders of the promisor and acted as it should have been prudent to him to act in the absence of any contract of indemnity if the promisor authorized to him bring defend the suit. Okay. Here the promisee or the indemnity holder can sue the another party which he was compelled to pay in such suit in bringing up the suit. For example, uh, there is a agreement of the contract of the indemnity between you and me. Okay, that you are entering into a specific kind of the business and I am entering into a agreement or the contract of the indemnity with you that if you are facing any kind of the issues in the business, I am there to help you, and along with that I'll be able to provide you the compensation that if you face any kind of the losses in your business, I'm able to pay you the compensation up to 5 lakh of the rupees. Okay. This is the agreement between you and me before ahead. So when this agreement is enforcing, what is happening? The person who is called as the indemnity holder. Okay. मान लो the party has suffered a specific amount of the losses in the business. Okay. So when the party suffered the loss in the business, who is the promiser to pay the losses? The promiser itself. So when the promiser here promised to provide the losses up to 5 lakh of the rupees, he is bound to provide the losses. But he is not doing that. He is not providing the losses. He is not following the rules of the contract. But in the other way, the promisee or the indemnity holder is specially doing his all kinds of the activity. He is following all the terms and conditions of the contract. He is following all the rules, regulations, provisions of the contract. So here, when the another party is totally able to follow with all the given procedure, but even after that, the person who is the promiser is unable to do his performance, and for that the promisee or the indemnity holder is going to the court of law and filing a case against the promiser that the promisee that the promiser is not performing his duty of indemnity. Then in that case, the promiser not only bound to pay the amount whatever he has promised before, also bound to pay the amount of the expenses which the promisee was compelled to pay as the court fee or as the expenses of the proceedings. That means the promisee over here brought a proceedings. He hired an advocate, he gone through the court proceeding. Just take an example that he had to expend around the amount of 3,000 to 4,000 rupees in the all the court procedure. Okay, so here he or the promisee, the indemnity holder, can sue the promiser to pay the court expenses up to the 4,000 of the rupees which he has brought against him. Because if he would have done his duty on time, then what was the necessary of the promisee to go to the court, to waste his time, to hire an advocate, and to do the court proceedings? That was not needed at all. But here, just because the promiser was unable to do his performance, the promisee has to bring a suit. So, when the party or the promisee is bringing a suit for the recovery of the compensation, he will able to recover the compensation according to the contract. And when he is bringing a suit for the recovery of the court expenses, then also he is able to get the expenses of the court fee and all the necessary requirements from the promiser, whatever he did in the proceedings. The third point, all sums which may have paid under the terms of any compromise of any such suit of the compromise was not contrary to the others of the promiser and was one which it would have been prudent for him promise to make in the absence of any contract of indemnity, or if the promiser authorized him to compromise in the suit. Okay, so when there is the compromise in the parties, so for example they are hiring an arbitrator, so whatever the expenses of the compromise proceedings, the promisee or the indemnity holder is also liable to get the expenses of the compromise or of the compromise proceedings which is continued against the promiser. Okay, so here we have learned three things under section 125. The first point, the promisee can sue the promiser for the losses or the indemnity. The second point, he or she can sue the promiser for the court expenses if he is at the right path, he is having not any kind of the mistake from his side, he has done his duty properly, he has followed the terms and conditions, but even after that the promiser is the one who has diverted from his duty, then in that case, the promiser is liable to pay the court fee even. Third, if the matter is not getting compromised in the court of law, but it is getting compromised by the mutual presence of the parties through the process of the arbitration, mediation, whatever it is, the process thereon, then in that specific case, when there is the conciliation proceeding or mediation proceeding or arbitration proceeding or compromise by the parties together, then whatever expenses the party is bearing in the compromise proceeding, that means the indemnity holder, he has the right to get the benefit or to recover those amount of the expenses from the promiser if he has done his duty properly but the promisee has lacked from his part. The first one, the uh, damages or the losses or the indemnity that has been promised can be recovered. Second, the case fees, the court expenses, if the promiser has done his duty properly. But if the promisee has done his part properly, but the promiser is the person who is lacking from his responsibility, then the promiser is liable to pay the expenses of the court expenses. Third, the expenses of the compromise proceedings which has been paid by the promisee can also be sued to the promiser to be paid. Okay. Then comes section 126, which speaks about the contract of the guarantee, surety, principal debtor, creditor. Okay. So this is explained under section 126 of the Indian Contract Act. So let's go through it. The first point, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. A person who gives the guarantee is called the surety. Okay. The person in respect of whose the default of the guarantee is being given is called the principal debtor. The person to whom the guarantee is given is called the creditor. Okay. So there are certain things over here. First is the contract of the guarantee. Second, surety. Third is the principal debtor. And fourth is the creditor. What is the contract of the guarantee? Contract of the guarantee is a contract to perform a promise or discharge the liability of a third person in case of his default. That when one party is promising to the other party that if he, as the promiser, is unable to perform the contract or if the party is facing any kind of the losses due to his own activity or the activity of any other person, then he is liable to pay him the compensation up to a certain amount. Then that is called the contract of the guarantee. So as I have given you an example of the business, that for example I am assuring you, I am indemnifying you, I am guaranteeing you that if you are entering into a business, I am here there to take up the losses up to the 5 lakh of the rupees. The amount of the losses can maybe, for example, I am also a part of your business, that if I am unable to deliver the goods to you, that if you are facing the losses due to me or due to any other person who is the outsider, I am here to pay the compensation up to the 5 lakh of the rupees. Got it? So here the contract of the guarantee is, that is a kind of the contract in which the promiser promises or guarantees to pay the specific amount up to a certain extent which is promised by him due to his own lack of the duty or due to the lack of duty by the other person. Then the second point, it comes about the surety. The person who gives the guarantee is called the surety. The person who is the promiser, who is giving the guarantee to pay the indemnity, is called the surety. Surety means the person who gives the assurance, that is called the surety. Then The next point, the principal debtor, the person in respect of whose default the guarantee is given is called the principal debtor. Principal debtor means in respect of whose default the guarantee is given. Okay. Principal means the primary. Debtor means who takes the debt or who takes the money. Okay. The person to whom the payment is paid or supposed to be paid for the lack of the performance or for any kind of the losses or damages, that is called the principal debtor or the primary person who takes the debt or who to whom the guarantee is given. Got it? And last one, creditor. The person to whom the guarantee is given is called the creditor. Okay. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. Okay. That means the person to whom the guarantee is given. That means, for example, the guarantee is given to me for the compensation of the losses occurred up to 5 lakh rupees in the business. Then I am the creditor over here to whom the guarantee of the payment has been. Okay. So the person to whom the guarantee is given is called the creditor. That means, mm for example, yeah, for example, we are entering into a contract where A has promised C to pay the amount of the 10,000 of the rupees. Okay. Where A has promised C to pay the amount of 10,000 of the rupees. Here, to whom the guarantee is given to do the payment of the 10,000 of the rupees. Okay. That person, the person to whom the guarantee is given is called the C. That means C is the creditor over here. A, who has given the guarantee or in respect of whose default the guarantee is given. A is giving the guarantee that if I am unable to perform my contract, then I'll pay you the amount of 10,000 of the rupees. So A is the principal debtor over here. And here B is the surety that if A is unable to do the payment, then on behalf of A, I will do the payment. So there is a new character has been introduced in section 126, that is called the surety. That here I am promising you that I will pay the amount of 10,000 of the rupees if I am unable to perform my part of the contract to you. Here there is another person B who is there as a surety, and he is promising that if Arya ma'am is unable to perform his part of the contract, or if she is unable to do the payment, then I will pay for her. That means in this contract there is the two parties who is ready to pay. That here first of all I am ready to pay for the lack of the contract from my side up to the amount of the 10,000 of the rupees. And if in case I am unable to perform my contract, then the surety, the person B, who is there as the surety of mine to assure me, to confirm me that in case I am incapable to do the contract or incapable to do the payment, that person is there to do the payment. That is called the surety. Okay. So there is these are the characters, the contract of the guarantee, surety, principal debtor, creditor. Contract of guarantee, what do you understand? That there is a contract between you and me. You are entering into the business. I am part of your business, and I am guaranteeing you that I am going to this much help to you. And if I am unable to perform my contract, then I will pay you the amount of the compensation up to 10,000 of the rupees. This is called the contract of the guarantee. The surety means there is a person B who is present at the surety, that if I am unable to perform my part of the contract, or if I am unable to pay you the amount of compensation up to 10,000 rupees, then on my behalf, the person B who is appointed as the surety, he or she will pay the compensation on behalf of me. That is called the surety. The principal debtor means I am the principal debtor over here who has done the promise, that I have done the promise over here that I will pay the compensation up to 10,000 of the rupees in the lack of my responsibility towards you, that I on whose default, if I am defaulting in my work, then I'll pay the compensation to you. Then here I am the principal debtor, and creditor, you are the person who is receiving all the benefits either from me or in my absence from the surety. You are called the creditor over here. This is the whole structure of the contract of the guarantee. Okay, so the next comes section 127, consideration for guarantee. What does it speak? Anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. So, what does it mean? Anything done or any promise made for the benefit of the principal debtor, okay, may be sufficient consideration to the surety for giving the guarantee. Okay, let's understand through an illustration. B requests A to sell and deliver to him goods and credit. A agrees to do so, provided C will guarantee the payment of the price of the good. C promises the guarantee of the payment in consideration of A's promise to deliver the good. Okay, this is sufficient consideration for C's promise. Let's understand this. First of all, there is a party B who requested A to sell and deliver to him a goods and credit. Okay, there is a delivery of the good. A is the seller, B is the buyer. Okay, B has requested A to sell the good to him. A agreed to sell that, but here A is A is putting a condition over here, provided C will guarantee the payment of the price of the good. Here A don't trust B for the payment. Then A is saying to B that if you are unable to do the payment of my goods, then keep C as the surety, that C will guarantee the payment of the price of the good. C will assure here that yes, this payment is must going to be done. So here if C is doing the promise, he is promising to do the payment of the goods. And she did this. She promises are guaranteed for the payment in consideration of the A's promise to deliver the good. Okay. This is sufficient consideration for the C's promise. That means here if A is delivering goods to B and B is unable to do the payment, then who is liable to pay over here? The answer is C. The surety over here is liable to do the payment over here. So, according to the section, anything done or any promise made for the benefit of the principal debtor, that means the principal debtor who is performing his duty, who is delivering his good in a contract, or who is doing his part of the performance in the contract. Okay, if any kind of the promise is being made for the benefit of the principal debtor, okay, may be a sufficient consideration for surety for giving a guarantee. That here, if the surety is giving a guarantee to the principal debtor, that yes, in case the person who is getting benefit is unable to do his performance, I am there to do his part of the performance. That if the person who has entered into a contract for a payment of a specific good, he is unable to do the payment, then I am there to do the payment on his behalf. That is called the contract of the indemnity over here. Okay, that is explained under section 127. Then from the next section onwards, Section 128 onwards, we are going to discuss in the next class. This is all for today, guys. We can just drop the class over here. Thank you. Bye bye.